is Valerie Drown, and I'm the director of the Alzheimer's Disease Caregiver Support Initiative. We have been leading this initiative in the North Country region since 2016 and are grateful for New York State Department of Health funding that we received to bring needed services to caregivers across 6 counties, which is Clinton, Essex, Franklin, Warren, Washington, and Hamilton counties. If you are a caregiver, we want you to be able to ask questions of speakers and other attendees that will help you in your day-to-day walk with dementia. If you are a professional, we want you to be able to network with others, asking questions, gaining an understanding of specific services that are available to assist with the referral process. So now I would like to introduce our keynote speaker, Heather Deare West. While she's coming up, I'll read her bio. Heather Deare West was born and raised in Plattsburgh, New York, where she attended Clinton Community College and SUNY Plattsburgh, receiving her BA in theater. Miss West attended Western New England College School of Law in Springfield, Massachusetts, receiving her law degree in 1999. She worked as an attorney with the Plattsburgh law firm of Stafford, Owens, Pillar, Murnane, Kelleher, and Trombley for 18 years, focusing on estate and trust work. In April 2018, Miss West joined the Rural Law Center of New York, located in Plattsburgh, and now serves as the Director of Civil Legal Services. The Rural Law Center of New York, a not-for-profit, provides free legal services to lower-income residents of the 44 rural counties in New York.
Thank you, Valerie. Good morning. I'm going to get real close to this table because I can't hide behind the pillar. But I think optically I should have the sun shining behind me. I should look like an angel with short, spiky hair. Thank you for having me speak to you. One of the things I like to do is discuss, I know, and you can tell I'm a thrill at a party, powers of attorney, healthcare proxies, wills. I am just fascinating at a party if you have those kind of questions. Otherwise, I have no small talk. What I like doing about these events, why I always kind of get so excited is, I've been a caretaker, right? I have been in some of your shoes. I know how difficult it is. I know how scary it is. So and I usually save this kind of speech in a different order, but I think to kind of get us kicked off, I want you to understand where I personally am coming from. So about 11 years ago, my mother, Victoria, was home with me. She typically was in England for half the year. Then she lived with me for half the year. She had a beau in England. She had family in England. But this particular day, she was home in the good old United States, across the pond, as they say. And she woke up, and she wasn't feeling well. And I don't know how it happened, because I am half English, but I had no tea in my house. Do you know what a great sin it is to be the daughter of somebody who's English and not have tea in your house? I also had no ginger ale and crackers. These are essential English ingredients if you are not feeling well. And my mother had been traveling and she wasn't feeling well. I thought maybe she had the flu. So off to the store I go, 45 minutes. When I get back from the store, my mother is still sitting in the same chair, but her eyes are listing to the left. And she can hear me and she can respond, but she can't look at me. And so I call an ambulance. And we get in the ambulance, and I knew something was terribly wrong because my mother would never go into an ambulance, but she had no objections this time. So I knew something was very wrong. We get to the ER, and it looks like she has a stroke, right? The doctors are looking at her, they're talking to me, they're talking to her, but she's not making any sense. And so they go do a bunch of tests. They come to me and they say, it looks like a stroke, but we're not sure. More tests. You know how the ER is. Gotta love the ER. They came back, and the doctor, who was significantly shorter than me, and this will make sense in a minute, comes to me and he says, Heather, it's not a stroke. Yay, not a stroke. It is a glioblastoma. It is a brain tumor that is incredibly aggressive. I wanted to punch him, and I was right at the perfect height, right in the nose. I did not. I did not punch him, but it's, I know, good choice. Yay for me. But that kind of reaction, that kind of visceral reaction about how dare you tell me this terrible news, and thus begun 8 months of caregiving. She had surgery. Eventually, her whole personality changed in those few days because her brain was swollen. What you would typically think of as an English grandma, with her little cardigan sweaters and her curly hair. Lorraine, who's sitting right there, knew my mother, knows exactly what I'm saying. You look at her and you think, English, right? No, she's wearing up a storm, threatening to disinherit me. Here are 2 events I take from that day that kind of explain the highs and the lows. The doctor came and told her she had brain cancer, and she looked at me and she says, I can't have cancer, you'll be an orphan. I was 48, right? In the next breath, she says to me, Heather, don't tell Richard. Richard was my stepfather. He'd been dead 10 years. Oh, gee. I said, Mom, Richard's dead. He's been dead for 10 years. And she looks at me, and the nurse is standing right there. She looks at me and she says, oh, good. He wouldn't understand anyway. I'm like, oh, great. And now the nurse thinks, well, not good things of me. So that 8 months was the most intense, the hardest, most heartbreaking time. And one of the things that I can be grateful for is we had had discussions long before this. I talk a lot, and so I get dry. About what kind of care would she want? What kind of things would she need? Of course, if your daughter's an attorney who does estate work, you have a power of attorney. You have a healthcare proxy. You've had discussions about what you want to happen should you ever come to that point in your life. So when I come to groups like this, I don't come just saying, you need a power of attorney, you need a healthcare proxy. I know you do, because I've been there. And I encourage everyone to have these documents. If you're not sick, have these documents. If you are sick and you can, have these documents. Because strangely enough, I consider it a gift to your family. Because in those horrible times, when you're trying to make 1,000 decisions, you don't want to have to worry, am I authorized to do this? Do I know what they want? Right? Or do I just think I know what they want? Can I go into the bank and make sure the bills are paid? Right? Can I order, do contracts? Can I get care in here? So the information I'm giving you today, and please feel free to ask questions, and I know that we're going to have another question and answer period after. Please feel free. So I'm going to start off with the basic, a power of attorney. And when I talk about powers of attorney, I'm talking about durable powers of attorney. A durable power of attorney is one that goes into effect when you, the agent, the principal. Great, now you're never going to trust me. You as the principal select, appoint an agent or agents. You can have more than one. And hopefully you also listen to me and appoint alternates to act in your behalf in financial matters, whether you are healthy or whether you are sick. Okay? Some powers of attorney, I think I rarely see them anymore. They would only operate if you were well. Well, to me, that kind of defeats the purpose. Mm-hmm. Now, it does have its place. Again, I told you my mother traveled back and forth to England a lot, so when she was in England, living up her life, having a fabulous time, I was here in America making sure her bills were paid, right? When she got sick, I continued that, and a lot more. So when we talk about doing powers of attorney, We want to make sure they're durable so that they stay in effect. You want to choose an agent that obviously you trust because you are giving them access to all your assets and the ability to make decisions about your assets, right? Now, one important thing, two important things actually. One, if you do a power of attorney, you are not giving up your rights to do whatever you want with your stuff. If you are still well and you have capacity, you're still the boss, which leads me to point two. If you appoint your children, kind of make them know, yeah, you've got a power of attorney, but I'm still boss, right? Sometimes children get really enthused about being powers of attorney for their parents because they think they get to tell them what to do. Sorry, no, doesn't work that way. The agent must be over 18, must be trustworthy, does not have to be a relative. Sometimes relatives are not the people that we need in that position. Now, I'm sure everybody here has fabulous children, fabulous grandchildren, would never do anything bad. I'm sure of it. But I have met some that are not, right? Or probably more likely may not just be good with money and responsibility. Maybe young. Sometimes I have somebody who only has like a 18-year-old child and doesn't want anybody else. I don't know about you when you were 18. I can only speak for myself. I was not reliable, maybe, at 18. Maybe I was a little wild, just a little. I would never cause my family problems, right? So you can choose somebody other than your family member. If your best friend is an accountant, maybe that's the person you want in charge, right? If your children have issues, drug addiction, alcoholism, they're not the best choice. That's okay. Because what we're trying to do is make sure that there are protections for you, right? Part of my job is emphasizing, I'm here to protect you. Again, I'm sure your children are lovely, but my job isn't to protect them. It's to protect you. And that should be your job as well. Protect yourself, okay? Some of these things, when we're talking about powers of attorney, we want to take into consideration, like I said, responsibility. I also want to take into consideration maybe locale, right? Is there somebody more local? Sometimes people want to name their children, but they live in Arizona, which is fine, absolutely fine. But if something needs to get signed immediately, do we have to go all the way to Arizona? Do we have to wait for things to happen? So that's another thing we want to keep in mind. You know, is there somebody local? Just in terms of access, right? I also always want you to name an alternate agent. An alternate agent is the person who steps up. I'm shining too bright for you, aren't I? Yes. Yeah, she put her sunglasses on. I'm shining. An alternate is the person who steps up when your first choice is unavailable or maybe has passed or moved to China. I don't know, right? The reason why alternates are important is if you become sick and lack capacity and your agent, for some reason, is unavailable, you aren't going to be able to make a new choice. You lack capacity. So you want to have that backup, because remember, we're planning for backups. My entire existence is based on worst case scenario. What's the worst case scenario? We want to plan for that, right? You can also have a monitor. A monitor is somebody who has the right to ask your agent, hey, I want to see the records and the receipts that you have been keeping. Unfortunately, abuse does happen. Sometimes people get a power of attorney, they take advantage, and money disappears, assets disappear. So to kind of check that power is you can name a monitor, somebody else, over 18, who has the right to ask for records and make sure that your agent is behaving themselves. Now, it sounds kind of difficult or strange because you're choosing somebody you trust, but we have a monitor. I have very broad shoulders. You can blame me, right? So if you're naming your child and your child's like, why are you naming a monitor? I'm your child. I would never betray you. Heather said so. Feel free. Feel absolutely free to use me and blame me. I can deal with it. One of the neat things about doing these sorts of events is, despite being in practice for 25 years, I still have to do homework, right? So I'm looking at the power of attorney law just to make sure nothing's changed in the last, 10 seconds that I looked at it the last time. But I also realized that the current power of attorney, right, has room for modifications. So regular power of attorney has limitations. One of the limitations is your agent can't make transfers on your behalf of over $5,000 a year. Transfers are not the same thing as paying invoices. Transfers are gifts. Your agent cannot transfer to themselves. That's conflict of interest, right? And again, we're worried about possible abuse. Now, you can modify your power of attorney to allow those things to happen. You can, if your spouse may say, I want my spouse to have the power to transfer assets to themselves, because typically that's who you're going to go to. If you have maybe significant assets and you're doing some tax planning, maybe you want transfers over $5,000. But here is probably the best modification that I think actually after we're done this, I'm going to have to probably modify my own regular form. You can modify the power of attorney to say, if in the future I need a guardian, right? I'm going to nominate Tracy. She runs my life anyway. Yes, wave Tracy. Yeah, she runs my life. I nominate Tracy. And if in the future I do need a guardian and somebody comes and says, here's the power of attorney, Heather nominated Tracy, and Tracy doesn't have any background issues. Do you, Tracy? Okay. Yet, you're right, yet. The court has to appoint her. I get to choose who my guardian's going to be. Because guardianships are last resorts, and we can talk about that in a few minutes. One other thing, kind of just paperwork issues. New York, over the last 10 years, has made significant changes to the power of attorney form. So the last form was in 2001. If you already have a power of attorney that was properly done prior to 2021, still good. You don't have to change it. But sometimes folks want to save money. And I say it like that because I'm being a pain. And they get something off the internet. 9 out of 10 times it's the wrong form. And therefore not valid. So if you're going to get a power of attorney, make sure you get the updated post-2021 form, right? Because I see a lot of powers of attorney where folks did it themselves and they've got the wrong form and it's no good. It's no good at all. The new form requires 2 witnesses, just like a will. And it has to be signed by you, the principal, and notarized. And your agent has to sign it, or your co-agents, however many you have. When the agents sign it is when it goes into effect. And the agents can sign it any time after you. So if they sign it a day after, they sign it a week after, a month, a year, that's fine. That is okay. New York allows for that these days. Okay? Any questions about powers of attorney?
So the 2021, everything before 2021 is...
No, if you have a power of attorney that you signed before 2021 and it was properly signed, it is still good. It's grandfathered. Okay. I'm saying using a form.
I see.
This today, a prior form isn't going to work. Yes?
Hello. So something that comes up a lot in my support groups is that each bank has their own power of attorney. That comes up a lot, that you have to go and make sure that you have their power of attorney. Not true?
No, not anymore. So part of the reason there was a new power of attorney law in 2021 is banks were giving customers issues, demanding that they use their power of attorney, which, again, if you at some point lack capacity, you can't make a new power of attorney. Now banks must accept a valid New York power of attorney or have to have a legitimate reason why to refuse. And there are, in the statute, there are reasons why they can refuse. But they have time frames. They have to have a reason. And it has to be a legitimate reason. If not, you can then bring an action against the bank and sue for damages. Yes?
What if I have a power of attorney for my mother, But she lacks the capacity, and I need an alternative. How do I get that alternative without her having?
Sometimes on powers of attorney. So the question was, she has a power of attorney for her mother, but does not have an alternate. Her mother now lacks capacity. How can she get an alternate power of attorney? You can't. Your mother can't name somebody, which is, again, why I say, please have alternates. Depending on the power of attorney, there might be a clause. You know how there's A, B, C, D, all the little powers. See if there's a clause that says that you, as the agent, can delegate powers to somebody else. May not be on every power of attorney, but see if it's there. And that would only be good as long as you were living. Powers of attorney end on death. All right? At that point, then you're either an administrator or an executor, depending on what the estate says. Yes, sir.
I have daughters living in Canada. Would they be able to have power of attorney?
Yes. Yeah. We do see that often because we're so close to Canada. We do see that quite often because we live so close to Canada. What I might recommend is if you have a New York resident, maybe make a New York resident a co-agent with your daughter. The only reason I say that is if there are any issues, New York court's like a resident. They want to be able to drag somebody into court and sit right before them. So that, or maybe have an alternate, New York alternate. But yes, it should be fine. Somebody need to take a call? Anything else? Yes.
Yes, I don't know if I'm premature, if you're going to touch upon it. The transition into a nursing home. We recently updated our power of attorney, durable and financial, and all the other, the will, the house, blah, blah, blah. But the lawyer was telling us, my husband and I, that, you're fine, ma'am. That there's a document that can be filled out by a lawyer when they're on a list to get in, your loved one, but it's gonna take a while, that you can come in. You cannot plan it ahead, like turning your house over to your children or whatever. You can go to your lawyer and have him fill out this document of transfer of assets from the husband. Will say, my husband has Alzheimer's. Am I premature in asking this? I didn't know if you were going to touch upon this.
It sounds like an assignment of personal property or an assignment of property.
Said you can turn your assets, the 401k, I guess this is what he said. A nursing home cannot touch the 401k, but your husband can transfer like retirement or any assets over to a family member. You both have to sign the document, but he's turning his assets over to a family member. So when he does enter a nursing home, they can't, now I'm not talking about the house, I'm talking about assets, to the one that's designated on the legal form.
I'm not.
And he printed out, there's an online site that gives you all the answers for what I'm talking about. I haven't had time yet to go on that.
Yeah, there are a couple of things that it might be, but I'm not quite sure if it's what you're talking about. So there's something called a Medicaid trust that you can create. And we'll talk more about that. That's towards the end of the conversation. There's an assignment of assets. It depends on who he's transferring it to, because it depends on who the property is being transferred to. So there's a difference between transferring stuff to spouses, which should never cause a problem, and then there's an issue transferring to other relatives like children, grandchildren, stuff. There are repercussions to doing that. So I'm not quite sure what that is, what that being described is. So we'll talk about that more when we hit wills and stuff. All right?
Could I ask one more question?
Mm-hmm.
Getting your loved one on Medicaid instead of Medicare, I don't know if
We'll talk about that
coming
too.
up or,
Just have to talk about that too.
Okay.
So yeah, so there's a kind of a preview of what we're going to talk about. I'll mention Medicaid trusts later on. We're going to talk about Medicaid. Everybody's favorite subject, Medicaid. Yes, sir.
One good question, going back to transferring of assets. If parents decide they want to give children money, and the children do whatever they so see fit with that, put it in an account, put it in their 401, redo a kitchen, you fill in the blank with whatever you want. Is there a particular period of time that Medicaid can come back or Medicare can come back and now what if the dollars are gone?
So we're going to talk about that. That's future. You're also eager. And I'm beginning to see that I should say Medicaid more. I got you. I got you. All right. So kind of wrapping up powers of attorney. Yes, everybody should have one. If you're over 18, get one. Have an alternate. Make some modifications. That guardian language, I think I'm going to start making part of my permanent power of attorney, just in case. Right? That's what I call powers of attorney and healthcare proxies, just in case documents. Just in case something bad happens. Yes, ma'am.
So, I don't know if you said this and I missed it, but when do you have to have it notarized?
Yes.
Okay. Each signature.
So the principal's signature, the person giving that, their signature has to be notarized and witnessed by two people. The agent just needs to be notarized, and again, the agent's signature can be at any time after the principal signs. Yes?
We had our power of attorneys done 2.5 years ago. Should that be redone every so often?
Not necessarily unless there's a situation change, like say maybe one of the agents is no longer available. But yeah, if your papers are still good and you don't have to change them, don't change them.
But if you wanted to do a guardian, then you'd have to go back to your attorney to have that done.
And add that language. You want to modify your power of attorney to add that language.
Okay, thank you.
Okay. So, yes.
I have the original power of attorney for my sister done in '96.
Okay.
And I have family members that came behind me when I knew my sister was incapable of signing anything. Said he's got power of attorney. Can that be?
That sounds more like litigation and a little bit more complicated than I can discuss right now because there are a lot of things going on with that. But we can talk about that after.
I agree with you about doing that, like trustees or power of attorney. Like for myself, I have my sister-in-law, which is about as old as I am. It would behoove me to get another person which is younger, honest, or more capable in case anything happens to any of us.
Yes, exactly. And that's why you want to pre-plan. Because if something happens to you and you're no longer able, you're still living, but let's say you're in a vegetative state and your first agent passes away, you have no one. And that leaves a hole for a guardianship proceeding, right? And we want to avoid that.
I know you're going to do this later on. My daughter has autism, and when I plan to set up a trust for her,
Yep.
is that very hard or to do? Or?
I've been doing those for 25 years, so for me it's not hard, but you do want to discuss it with an attorney. And again, I can talk to you about that after. I am going to kind of briefly mention it.
I know, I'm looking at that, and I'm not getting any older. I don't have much to give her. She has property and a little bit of money, and I want to make sure it's safe there.
Yep, we're going to talk about that. We'll talk about that. Okay. All right, now on to the exciting world of healthcare proxies. Yay! All right, healthcare proxies. Now we have samples at the back where Tracy is. Everybody say hi to Tracy. There you go. We have little mini healthcare proxy cards that you can put in your wallet. And we actually have some information. Healthcare proxy, what is it? It is a form where you, the principal, choose an agent. Unlike a power of attorney where you can have multiple agents at the same time, New York law only allows for one agent at a time, okay? You choose an agent who can speak on your behalf to doctors, medical facilities, when you can't speak for yourself anymore. You are incapacitated. You are unable to appreciate the medical decisions that need to be made. You cannot answer your doctors. You may have dementia, you may be sick, you may be unconscious, but you've chosen somebody who can speak for you. And now when I say speak for you, I mean speak for you, in that that person has to abide by what your wishes are, okay? Now your wishes can be anything. Yes, I want everything under the sun tried for me. No, I want nothing tried for me, keep me doped up, I'm good. Or somewhere in the middle, right? So that leads me to this point. Sometimes, and not for nefarious reasons, family members may not be the best choice because it's hard. It is the hardest decision you may have to make, is being able to say, enough. I know mom doesn't want that anymore, right? That is an incredibly hard decision. I'll tell you what's harder, not knowing. At the same time my mother was sick, another friend of mine, her father also had cancer, and they were on parallel tracks. Her father died 10 days before my mother died. Both had cancer, both were on morphine, both were having all these medications. At the end, I knew what my mother wanted. I'm trying desperately not to touch the microphone, sorry. I knew what my mother wanted, I knew how she felt about things. And I was certain about that. Not only me, but my brother and sister too, okay? Because we had had these conversations. Again, if your daughter's a lawyer who does estate work, joy, you get to have these conversations all the time, right? So I knew. My friend Debbie was unsure. And about a month after both of our parents had passed, she came to me, she goes, I don't know if I did the right thing. I don't know. And that haunts her, right? That's a horrible, horrible feeling, to not know if you did the right thing by somebody you love. So, healthcare proxy. Tell us what your decisions are. Have the hard conversation. Doesn't have to be on Christmas Day. Doesn't have to be on Thanksgiving, but you have to have the conversation. And it should be a continuous conversation because things change. Our views change, right? You need to tell your loved ones, this is what I want, or I don't want this, or give me some time, right? That's what a healthcare proxy is. You as the agent have to follow those person's wishes. And again, sometimes a family member, it's too hard. A spouse, it might be too hard. And that's okay to name somebody else. It really is. Because again, this is, in a very odd way, a gift, right? There's certainty in this. So that's what we want to be able to do for our family. Now, another thing is something called a living will.
Can we get a question about the proxy?
Yes.
Do you have proxy sheets to fill in back there that are...
We have them on the back of the form, Tracy? Well, we have the mini cards.
Okay.
Okay. If you want, this is going to be a little bit later, but if you want a form, you can go to the New York State Department of Health. And if you look up healthcare proxy, there will be a link that will bring you to a healthcare proxy form. You will need to sign it, and you will need 2 witnesses over the age of 18 who are not the named agent. But everybody signs at the same time, okay? A living will, because there's healthcare proxy and there's a living will. Typically, our office, the Rural Law Center, does not do living wills because there's really no set New York form. The healthcare proxy has a law, a genuine law that says, here you go, this is how we do it. Living wills have what we call case law. It's based on things that have actually happened in the past. A living will doesn't tell us who, it tells us what. What do you want done? You put that out in a living will. If I have to choose, I'm going to choose a healthcare proxy because it's broad and it covers everything, but a living will gives guidance. And sometimes, again, when you're in the heat of the moment and things are crashing down around you and you can't think, sometimes it's good to have something in writing. The New York State Attorney General's office, if you go online there and search for a living will, they have a form. And it kills me to say it, you don't need a lawyer to do these. You don't have to have a lawyer to do a living will. You don't have to have a lawyer to do a healthcare proxy. I do strongly suggest you have a lawyer do a power of attorney, though. But healthcare proxies, fine. Put me out of business. There are other things as well. So, these advanced directives. So, hopefully you have a healthcare proxy. At minimum, have a healthcare proxy. I think a living will is helpful. Gives us what your wishes are. I do want CPR. I do not want CPR. I want medication for pain, on whatever you want.
So what about the spouse? Like, my husband he didn't have a healthcare proxy set up, but all the decisions went to me.
Yes, I'm going to talk about that in a second. Y'all are jumping right ahead of me.
I have a quick question too. Where does the most for?
Again, jumping right ahead of me. Wow, you people are eager. Okay. Healthcare proxy, living will. Those are things that you can do on your own. You don't need an attorney. But things like a MOLS form, which stands for a medical order for life-sustaining treatment. And if you want to see what it looks like, you can go on to the New York State Department of Health website, take a look at it. Those are done by your doctor. If you have a serious illness, a terminal illness, these are actual medical orders that follow you around. So if an ambulance comes to get you, maybe you have what's called a non-hospital DNR, do not resuscitate, or DNI, do not intubate. Those are all things you create with your doctor. And I think those are more dependent on your illness. It's not something you necessarily have if you're just healthy and you're wandering around. But if you have a significant illness, cancer, heart disease, something like that, those are things you discuss with your doctor or your medical practitioner. And they help you fill out those forms. And they, I believe, check them, I want to say probably every 6 months or so. I think depending on what it is. They just want to make sure it's still what you want, right? Because if an ambulance comes to your house and sees a do not resuscitate, that's what they're going to do. They're not going to do anything, right? So you can have those as well. So you completely ignore everything I've just said. Doesn't hurt my feelings at all. You ignore what I say, you have nothing. New York State does have the Family Healthcare Decisions Act. Okay, it is a law that New York has that says if you don't have anything, we're going to say who gets to make decisions about you. And there is, and I knew somebody was going to ask me something that I'm going to have to remember, and I can't. I'll tell you who's who. No, I won't. I'm going to go off my memory. Spouse or guardian, or a domestic partner has first choice. After that, it's adult children. After that, it's your parents, sisters and brothers. It goes down the line, okay? The decisions, again, have to be based on their knowledge of you. If they don't know how you feel about certain things like life-sustaining treatment, they can't make those decisions. So again, even if you ignore my good advice, my free legal advice, and don't have anything, have the conversations. So at least under a Family Healthcare Decisions Act, they can speak to what your wishes are. Okay? So the legal term is the Family Healthcare Decisions Act. And it is a New York law that tells us who gets to make medical decisions for you, again, if you lack capacity and you haven't chosen an agent. And hopefully, at minimum, when you leave here and after you sing my praises, you have the conversations. Heather said we had to talk about this. Again, I have broad shoulders. You can blame me. I'm okay. So any questions about the advanced directives? Yes, ma'am.
So for the healthcare proxy, what you said was if you are incapacitated, that person makes the decision. Who, or is there something that determines that person is incapacitated? Because
Yes.
if you ask my mother questions, she will answer you.
No, so capacity is determined by doctors. It is a medical determination.
Okay, done prior to the necessity?
Yes.
Okay.
Yeah. Or at the moment. So let's say you come in an emergency, like when we went into the ER. My mother did not have capacity. Talking about my dead stepfather and how glad she was he was gone, right? If you regain capacity, decisions come right back to you.
Okay.
Okay? So yes, it is a medical determination. And capacity, we have this discussion a lot in a lot of groups I belong to, and Valerie's been in these discussions as well. Capacity is a fluid term, right? So what I may deem capacity to sign a will may not be the same as capacity to make a healthcare decision, right? They're very fluid terms. You can have Alzheimer's and still have capacities to make your own decisions. I think what happens is sometimes people take a very black and white view of capacity. And sometimes, I know it's hard, people will make decisions you don't agree with. That doesn't mean they lack capacity. People get to make bad decisions. It doesn't mean they lack capacity. Right? We have to be respectful of the person and the situation at that moment in time. Okay? Any other questions about the healthcare directives?
So the medical determination you're talking about, is there a form that the doctor has to fill out?
Yeah, I believe he's going to make a medical determination, so it's going to be in the medical records. So yeah, it's going to be written down. Doctors have to write everything down because we lawyers tell them to write everything down, right?
The other question is, you have the power of attorney, health proxy, living will, documents are created. The question is, where do these documents reside? You have them with a lawyer, perhaps a lawyer quit doing business, maybe he died, who knows where the form went, you know?
So it depends on where you get them done. If you get them done with the Rural Law Center, our services are free, if you qualify. We give you the originals back, we'll give you copies. Attorneys may keep theirs in fireproof safes, give you copies. If an attorney retires, they have to notify their clientele that they can either pick up their records or where their records will be kept, right? But you are entitled to, if you say to the attorney, I want to bring the original home with me, you're entitled to it, it's your document. All right? Keep them someplace fireproof. My favorite, if you don't have a fire safe box, your freezer. Put them in the freezer, wrap them up, put them near the beef. But let's think, if your house catches on fire, usually the refrigerator is the last thing that goes.
Quick power of attorney question. We have completed one. My father and I and my mother, we did one. He has the original in a safe.
Okay.
I have a copy. If for some reason that original cannot be located, will my copy be valid wherever I may need to take it? Okay.
Copies should be accepted. What you may want to get is something called an attorney certified copy, meaning that when it's all signed, the attorney puts a stamp on it that says this is a genuine copy.
There's a stamp on the original,
Probably a notary stamp.
but there's some type of stamp. I'd have to go back and have them pull it out, but I don't believe there's anything on mine other than.
Yeah, because you would need to, like if you brought the original to me and I made a copy of it, I could then verify that that's an authenticated copy based on the original.
So we may chat.
Yes. What you can also do with a power of attorney, if you want, is you can file the original at the county clerk's office. I think it's a filing fee. I don't know if it's $5 or 45, whatever the county charges, so that it stays there forever. And the county clerk can give you certified copies. That's one way to keep it safe. The only time you have to file a power of attorney, because it's optional, but the only one instance where you do absolutely have to file a power of attorney is if the agent is using it to sell real property, to sell a house, to sell land. Then it has to be filed with the county clerks. Otherwise, it's optional.
Yes. I have a question about the capacity. Would that be the primary care that would make that decision, or is it?
I think it's whatever physician is taking care of the patient at that point in time. So the primary caretaker, again, it depends probably on the illness. If it's something that your primary caretaker is known, sees you regularly, can probably make a determination. But say you're in an emergency situation. It may be the doctor's right then and there. And again, it may be temporary. Like after my mother had her surgery, she came back to being the sweet English grandmother that I knew. Not the raving lunatic who was threatening to disinherit me and talking to my dead stepfather. Right? So again, capacity, all I can say is it's a fluid thing. Like in my 25 years of practice, that now when I talk to people who may have come to me and say, I've been recently diagnosed with Alzheimer's, I need to make a will. I don't automatically say no, just because they have that diagnosis. Could be the early stages. There are some times where I'll have a client who's good in the morning, bad in the afternoon. Is that sundowners? Yep. Sundowners? So for signing a will, they may have capacity in the morning, not in the afternoon. And trust me, if I do have that sort of thing, I have records, right? So yeah, capacity it's a tricky thing. Yes?
I have a question back to the power of attorney. If you have a child and they're your power of attorney and they have a career that people can possibly sue them, can they go through that link and go after that? No? Okay.
No. Power of attorney, it goes to your assets and your assets only. If it is a concern, by the way, you can revoke a power of attorney anytime. You can do it in writing. Same thing with a healthcare proxy. These documents are good until you say otherwise. So you can always revoke that.
So how do you, okay, so you're the principal and you revoke it, or you can change it. And how does that how does that show up? Like, let's say I have a copy of power of attorney number 1, and I don't know that there's a power of attorney number 2 or 3.
So as the principal, you got to send everybody a copy of that revocation and a copy of the new power of attorney if you have one. You have to notify. You have to notify the agent. Hey, by the way, you're no longer my agent. Right? You do it in writing. And then hopefully you make a new power of attorney. Yes?
Do you have to go to a lawyer to have it revoked?
I so want to say yes. And I strongly suggest, in all honesty, you do. You don't have to. You can put it in writing. I revoke this power of attorney dated whatever day you are no longer my agent. Technically, you could do that. But I would recommend hiring an attorney or, again, reaching out to somebody with legal services like the Rural Law Center. Do you like how I plug that in every few often? Only because powers of attorney are complex documents in that 6-7 pages has a lot of power, right? Because you are giving somebody access to everything, all your financials, right? Oh, and by the way, just to make sure, powers of attorney do not make healthcare decisions. Healthcare proxy is something separate. I know in Vermont they can be on the same document. Here in New York, 2 separate documents. All right, so on to the next. So usually I talk about last wills and testaments at that point. But when we're talking about caregiving, there are some other options as well. So quick hit, a last will and testament is a document where you, the testator or testatrix, tell basically everybody in the world what you want to happen to your assets when you are no longer with us. You are gone, okay? You can do whatever you want with your assets, by the way. A couple things you can't do, and I don't know. Again, I'm sure all of you have happy marriages. You can't disinherit a spouse completely. If that was just somebody's thought, you know. Can't do it. You have to leave them a minimum of 1/3. Occasionally I get that question, but I'm sure I see all these lovely people here. None of you would ever consider doing that. Above and beyond that, you can do whatever you want with your property. It's your property, you earned it. If you want to leave it to your children, good. If you don't want to leave it to your children, good. Want to leave it to your best friend? Good. Grandchildren? Good. I don't hold any judgments about what you want to do with your property. That's not my job. My job is to somehow create a document that gets your wishes done. In that document, you also have an executor or an executrix, if we're being fancy, the person who's going to be in charge. You always want to name alternates, including to your beneficiaries. If A dies, then B gets it. If B dies, then C gets it. If you have special things, specific things you want to go to specific people, put that in your will, please. The biggest fights I see are not necessarily over money, though money's fun and it is always an argument, but the bitter fights are about the sentimental things, the special things, the family heirlooms. Mom said she was going to give me grandma's quilt. No, Mom told me she was going to give me grandma's quilt. That goes for a couple of uncomfortable Thanksgivings, right? Mom loved you more. She's giving you the quilt, right? You don't have to leave things to your children, right? There are reasons. Again, I'm sure all of you have happy, lovely families. Sometimes people don't. You don't have to leave everything to your children. Leave it to charity. You can set up a pet trust. Make sure Fido's taken care of, right? A couple of things. I think we're going to talk about what we can do in a will. If there are certain aspects of your life that need special care, say your child has special needs and receives benefits like Medicaid. You don't necessarily want to leave them everything outright because it could cut their Medicaid. We never want to do that. Doesn't mean you have to disinherit them, though. That's the old way. These days you have what's called a supplemental or a special needs trust that you can build in your will or you can create during your lifetime. And what that special needs trust does is says, if this, I'm going to pick on Lorraine because I keep seeing her and she's right here. If my daughter Lorraine, who has special needs, inherits a part of my estate, she's not going to get it outright. It's going to go in this trust for her benefit, but she never controls it, she never owns it. That keeps it out of Medicaid's assets. So the money can be used to take care of her in ways that are not covered by her benefits. So like say she wants to go to Disneyland, that trust can pay for it. But it can't pay for her medical expenses because she has Medicaid. That's a way you can take care of somebody but not endanger their benefits. So that's what you were talking about, sir. Yes?
I just have a question about who can be an executor of a will.
Okay.
What are the categories of folks who can't? Like someone had mentioned a Canadian address.
When we talk about, say, foreign nationals, I want a New York resident as a co-executor because the court needs somebody they can haul in and hold responsible if something goes wrong. And you can't do that with a Canadian citizen. You don't have, the courts don't have jurisdiction over there. So I would have a co-agent or a co-executor. Anybody who's over 18, trustworthy, reliable, not a felon. There are some rules where that's a little wishy-washy, but generally not a felon. Not anybody who has a drug or addiction problem. And you have to be able to speak English because you got to be able to know what's going on. Read and write. But yeah, sometimes, and we would get that occasionally when I was in private practice, we would have a lot of Canadian clients, so I always had to have a New York resident. And that person doesn't have to be a person. It could be a bank. It could be a trust company, an accountant. It could be a professional. It could be your lawyer. I personally am not, I don't ever want to be anybody's executor other than my family's. Sometimes I get that question. I'm like, no, I don't know. To me, it's not.
I've had one too. This way, prior to this, where let's say your mother, your father, or whoever has property and household items. Talk to these people. Have it written down. Let's say I wanted the sewing machine, and she wants the china. And would that be legal binding?
In a writing? No, it's got to be in a will.
Pardon?
You mean just kind of like in a writing?
Yeah, put it in writing, a sheet of paper.
It's not going to have the same effect as a will. A will is, that's the law.
I'm trying to think of eliminate a lot of ill feelings during that.
Well, here's the thing. That's what the will's for. That's what the will is for, to eliminate those feelings. If you haven't gone through grief before, you may not know this. Grief does really weird things to people, right? You've got all these emotions. You don't know what to do with them. right? And all these old hurts may come up because there's no way to address them anymore, right? So grief does really odd things to families. So this is why I prefer having everything in writing, so that we can try and avoid those fights. Now, a couple of alternatives to wills, which is what I wanted to talk about. So like a trust. You can create a supplemental needs trust. You could create a trust in your will for grandchildren who are under 18. Please do not leave minors' gifts outright. Otherwise, you're going to land up, well, you won't land up in court because you're gone. But your family will end up in court because you're going to need a custodial guardian for your grandchild. And that may not be the person you want, right? Maybe your daughter married a schmuck, and you don't want the schmuck being the trustee, right? Put it in the will, you can create that. If your children have issues that, again, you don't necessarily want to disinherit them, but you don't want to give them a big chunk of cash for addiction, alcoholism, they married a schmuck, put it in a trust. You can create these documents in a will. You can also create them during your lifetime. The fancy word is inter vivos trust. There are basically two types of trust. There's revocable. It's like the hokey pokey. You can put things in, you can take it out, do whatever you want with it. Irrevocable, you put stuff in, it stays there in one form or another. And every other trust is built between those two trusts. And trust can be created for anything. Anything. Yes?
Can I ask about, well, two questions. So if you have a will or power of attorney and there's executors, but then they were written a long time ago, and then they, because of the two things we talked about, let's say one is has a Canadian address, whatever the situation is that they can't be.
Right.
Well, who does it fall to then?
Okay.
So there's that question. What happens there? And then also, if you have a home in a trust, can that home be sold? You haven't passed yet, but like your executor of the trust, what do they do with the home if they don't need it anymore?
Okay.
Can we handle the home?
Okay, so first question is, what if all your executors or your agents die? Okay. If you hopefully had a will, right, and both say you ignore again my good free advice, don't have alternates, then one of the beneficiaries could petition the court to be the administrator CTA. CTA, cum testamato annexio, Latin for with will attached. There are certain people who can be administrators. It all depends on who's who, but there is a preference, a priority list. So somebody from that list, okay? In a trust, let's say you put vacation home in the trust. The trustee can sell that home, and depending on the type of trust it is. So if it's revocable, you may just want to take the house out and sell it and keep the money, right? Right? If it's irrevocable, you've put the house in. So you say, I don't want that house, and the trustees say, or whoever, your trustee in charge says, fine, we'll sell the house. They'll sell the house, the money goes into the trust. So you're flipping the house for money, and it stays in the trust. And then whatever the trust is instructed to do, that's what it does. So you may get interest income from the trust.
But the trustee can make the decision to sell a home
Yes.
of a living.
Yes. Yes. So say you've got the family home there, but your parent needs to go into a nursing home, and you don't want to pay for the upkeep of the house. If the house is in the trust, the trustee can sell it, have that money in there for the care of your parents. But the money stays in the trust, usually. There are things called Medicaid trusts, right? So since we're going to veer right off on that topic, a Medicaid trust is an irrevocable trust, meaning whatever you put in does not come out, that you transfer assets in, hopefully beating, bless you, the 5-year look-back period, which I'm going to talk about, okay? So Medicaid, and please note that this information is as of this minute, this day, right? Lots of changes are occurring. I cannot guarantee that this information is going to be good tomorrow, this afternoon, 1 hour from now, but at lunch. So when we talk about nursing homes, unless you are fabulously wealthy, most everybody's going to need help paying for nursing home care. the major resource of that help is going to be Medicaid. Now, first rule of Medicaid, I tell every single patient or client of mine, Medicaid doesn't want to pay for you. They don't. And so they make it incredibly difficult to do this. And what they'll do is they'll take a look at your assets, make a determination. And not only are they looking at the assets you have now, they're going to look to see if you gave anything valuable away within the last 5 years prior to applying. And if they do find that, say you put a house in a trust, they're going to say, hey, you had an asset. You gave it away. You could have used that to pay for your care. So we're going to take that asset and pretend you still have it. And this is what we're going to do. We're going to take the value of that asset and we're going to divide it by the cost of nursing home care in your area. And we're going to come up with a number. So let's pretend, because I'm a lawyer, not an accountant, that a house is $100,000, care is $10,000, and we come up with the number 10, right? Divide the $100,000 by the $10,000, you come up with 10. Am I right? Okay, because remember, not an accountant. So for Medicaid purposes, 10 represents months. 10 months is a penalty period, which Medicaid says, hey, you won't qualify otherwise, we're going to bring you into our program, but because you have that house that you could have used, you have to pay a penalty period of 10 months. You have to pay out of your own pocket for the first 10 months, and then we'll kick it, right? So sometimes people will create Medicaid trust. Again, you still have to face the 5-year look-back period. But what it does is if you put all your assets in it, everything, except IRAs, because the IRS has technicalities on that, and you beat the 5-year look-back period, your assets are in a trust. When you die, and you've put all your assets in the trust, all of them, every single one, you avoid probate, right? Probate is the process of taking the will, going to the court and saying, hey, there's property, I need to get it transferred, I need to be the executor. If you have a trust and you've completely funded it, you don't have to do any of that. So why is that important for Medicaid purposes? Medicaid wants their money back. And the way they do it is when you die and you have to probate your estate, Medicaid puts a lien against your estate. They want their money back. So whatever assets are in your estate are going to be cashed out and repaid to Medicaid first.
Even if you had this before the 5-year look back, they still go after you?
Yep. Yeah, so no matter what you've done, if you get Medicaid for nursing home care, and well, there's a technicality, but I'll go over that in a second. And say you didn't do anything. You didn't put anything in a trust, you didn't do anything. Any asset that has to be probated, right, and you have to go to court, Medicaid says, hey, you have assets, we want our money back. They put a lien against your estate. But if you have a trust and you put everything in it that you can, and you don't have a probate estate, one that has to go through court with a will, Medicaid can't touch it because it can only go after the probate estate. That's why people are willing to take the chance. And sometimes folks, I see a lot of this. I don't do a lot of Medicaid trusts. They're beyond the scope of what our service is, but we do a lot of deeds with life estates, right? So a deed with a life estate is where the owner would transfer the property, typically to their children, and keep a right to remain on the property, live there. Nothing really changes for you. You still pay the taxes, you still pay the insurance, all of that good stuff. When you die, the house automatically belongs to your children because they have an interest in it. It stays out of probate. And so Medicaid can't touch it. But you got to be aware of that 5 years. Got to beat that 5 years. Now, technically, let's say you do this and you have to go before the 5 years. Medicaid still can't touch the house because you don't own it. But typically, for most folks, the house is the biggest asset. So in the end, most kids are going to say, we're going to have to sell the house anyway to pay for mom's care because we're going to have a penalty period.
Oh, if you don't meet the 5 years.
Right. Okay. Right. But if you're willing to gamble and you keep the house out of your probate estate, Medicaid, and again, like I said, if you transfer the house, your kids aren't forced to sell your house, but then mom's got no money to pay for nursing home care. Where's mom going to go? So most kids are going to land up selling the house anyway. It's just the reality of it.
Can you speak about the exceptions to that, like if a child lives with that parent? Or
Yes, so there are exceptions to that. You can transfer anything to a spouse, no worries. If you have a disabled child who lives in the house, they won't touch the house. If you have a sibling who has an equity interest in the house, also if you've had a child who's lived in the house and has been a caretaker, I believe for 2 years, they can't force that child out of the house. Yeah. See, I knew there were going to be Medicaid questions. I should have done homework.
What about the, what did you say about the spouse?
Transfers between spouses are no limitations. You can transfer whatever you want to a spouse.
Okay. But what does that mean?
So that if I transfer my property to you, say we're married, we're progressive. We're married, I transfer my house to you, and then I go into a nursing home. There's no 5-year look-back period for that because I'm transferring it to you as a spouse. But if, as my spouse, you turn around and sell the house within 3 years or something, then Medicaid's going to say, obviously, that was just a faux transfer.
So, all right, so my husband and I co-own the house. So he transfers his portion to me.
Depends on how you own the house. So owning property, here's another thing that might avoid probate. Again, if we're looking at trying to save assets, you can be a joint owner with rights of survivorship. You can be tenants by the entirety, which is what husbands and wives are, or spouses, forgive me. Now, joint tenants with rights of survivorship and tenancy by the entirety do not make math sense because you both own 100%. But that's the law. So if one of you passes, the other one still owns the property outright. You could be tenants in common and each own individual shares. That is a probate asset. Yes, Lorraine?
For example, my parents and my siblings are on the deed to their property as joint tenants with right of survivorship.
Right.
So my parents pass.
You and your siblings own the property outright. Yep. I see Valerie back there. I have a feeling I've talked.
I was giving you your 15.
See, I will talk about this sort of thing.
Yellow light.
You see yellow light. I will talk about these things all day long. So sorry. You won't be trapped here all day long, I promise.
I have a will question, go back. First of all,
Yes.
you did my will, fantastic. You did a fantastic job. I recommend anybody go to. But secondly, if there is a change needed and spouse and I are on it, but he is not in the capacity to make the change, to take someone off, can I do that?
Nope. With wills, the person giving the will must make the changes. It cannot be done by power of attorney. Absolutely cannot be done by power of attorney. Yes?
Could you tell me if the house is put into the children, okay? And then there's a thing saying that your mom can live in that house until, what does that?
That's called a life estate.
Life lease. Life lease.
Well, there are two different things. There's a life lease and a life estate. A life lease gives you the right to live on the property. That's it. A life estate gives you the right, gives you an interest in the property. You can live on it, but you also have other rights. You could, if you wanted to, rent the property out and keep the income. You could have somebody come live with you, and they live in your place. That's okay. There's a subtle difference, but there's a difference between a life lease and a life estate. A life estate has more rights. And it's usually described in the deed itself if you're not sure.
I just want to know if I pass away, can Medicaid take my house?
If you've done nothing to your house, if you haven't transferred it or done anything like that.
Well, everything's transferred over to both of my children.
Okay, so if it's transferred over to your children, Medicaid can't touch the house. Because when you die, you don't own the house. Medicaid can only go after your assets. So if you have a life estate or even a life lease in the house, but you've transferred it to your 2 children. When you die, it's automatically theirs. Medicaid can't touch it.
Medicaid can't touch your assets or anything?
Can't touch the house. If you have other probate assets that need to go through the court, Medicaid can go after those after you die.
Give me an example of a probate.
You own a house in your name alone that you leave to your children. So when you die, the children will take the will where you've said, I give my house to my kids. So the will just tells us what you want to happen, and it nominates an executor. Nobody's actually empowered to do anything by law yet. So you have to take the will, petition the court, and the court's going to look at everything, says everything looks good. So-and-so, you are now the executor. You are empowered to start gathering the assets, paying the bills, which always come first, and then whatever's left over, you will follow the terms of the will and make that happen. So the executor would sign over the house to your kids if, again, barring any liens or debts or anything like that.
So it's basically the house and your dad.
It can be anything. It can be your house, it can be your car. Now, there are things called small estates where it's just personal property for less than $50,000. It's not full probate. There are, sometimes it's just a bank account, which actually, I'm going to sneak this in real quick, Valerie. Other ways to kind of avoid probate, you can have payable on death. You can make accounts, payable on death, bank accounts, life insurance. Those are payable on death. They bypass probate because all you have to do is fill out paperwork and your heir gets it. You can have transfer on death. Those are usually stocks. You can contact your stock company and you say, I want my stocks transferred upon my death to whoever your beneficiaries are. Right? So again, those are things that avoid probate. You can have a trust. If you put everything in a trust, it avoids probate. Yes?
What happens if, like, you don't get around to making the will?
First of all, you hurt my feelings. If you do not have a will, and again, have ignored my free legal advice, New York State tells us where your money goes. You may or may not like that. Your spouse, if you're married, will get the first $50,000 of your estate and 1/2 of everything else if you have children. Your children will get the other half. Doesn't sound so bad unless you are on your second marriage, or third, or seventh.
What if you have adult and minor children? How does that?
It's still divided between your children. However, again, if you have a spouse or not, or if it all goes to your children. If you have minor children and they inherit anything over $10,000, then a custodial account has to be set up, guardianship has to be appointed for your children to manage their property because 10-year-old can't manage money. So the court, and it's a court process, which means it's going to take time and it's going to take money, and the person in charge of that may not be the person you want.
How's that decided?
Court. Court tells us.
People stick their hands up?
Well, let's say you're the father. Let's say you, I have no idea, say you had a bitter divorce and you're not particularly fond of the father. But if you die and you have minor children, the court's going to look at the father first. But if you set something up in your will that says, if my minor children are the heirs, I want my parents to be the trustees. I want them to take care of all this money. Right? That's how you get control over those things. So there's payable on death. I'm trying to remember. I have my notes here. They were of utter no use. Let's see. Did I hit everything? Healthcare proxies, your family, guardianship. We don't even talk about gift taxes. Make gifts. One way, again, to avoid probate, make gifts before you pass. Now, you can make gifts up to $19,000 a year, tax-free. If you go over the $19,000, there's a federal gift tax, but do not worry, because every one of us has a federal estate/gift tax credit. And if anybody meets that, come talk to me after. I want to be adopted. That credit is worth $13.99 million. That's the federal. Well, what happens is if you give a gift over $19,000, you have to file a federal gift tax. But you're going to use part of that $13.99 million to pay the tax on the gift. It's paperwork. New York does not have a gift tax, but New York, of course, is super complicated. New York is, I think, $7.6 million for state tax. But it doesn't have a gift tax. But they're tricky, because it's New York. And what they can do, depending on your state, is they can claw back the value of your gift if it's done within 3 years prior to your death. Sorry. But again, we're only worried about that if you have over $7 million. And again, if you do, come say hi to me. Yes?
Is this paper available?
No, these are literally my scribbled notes that I did not use. I always have a plan, and then I kind of go, like Val says, I kind of just go off and chat.
Question.
Yes?
I know your Virginia is probably getting close. What about IRAs? You mentioned, that's another ball.
So an IRA, we don't put those in trust because if you move the IRA, it's a payout. And the IRS says, hey, you just paid out your IRA completely. We want our taxes, so don't ever do that. We don't do that.
Your lawyer.
I still have the will that my wife and I had. She passed. And is it still legal?
Yes. Your will is valid until you revoke it. And you revoke it either by destroying it or making a new will.
Okay. And second of all, can I legally cross off people I want on that will?
I'm going to say, again, you hurt my feelings. You want to make a new will. You want to make a new will. Because by crossing it off, you may actually have revoked the entire thing. So just make a new will. Come see me. If you qualify for our services, come see me. If not, hire another lawyer. But yes, and another reason, again, while your wills are still valid, even if they're 20 years old, you may still want to update it simply because some old wills may not have the current requirements, like a witness affidavit. So part of proving the will, making sure it's the real will, is witnesses used to have to come into court and say, yes, that's my signature. Yes, I saw them sign it. These days we have affidavits that we do at the same time when we sign a will so that we can avoid that. Because you know, if you're going into court, you're paying a lawyer for that.
Sure. But if a lawyer is
no, you still have to prove it. You still have to prove the will. So the lawyer should have a witness affidavit attached to the will. Yes. And that way it will save having to go into court, actually, to prove it, because the court will accept an affidavit. Yes?
No reason why you should know this, but do you know what the Medicaid rate is, monthly Medicaid rate is for that right now?
What do you mean?
I know what it was 24 years ago when I worked there.
For nursing home care?
Yeah, for nursing home care.
I think it's around $13,000, somewhere between $13,000 and $14,000. It's always lower than the actual cost. Because I think nursing home care these days is $16,000 a month. Yes.
How do you qualify for the grazing?
You go and do an intake on our website. We are income-based, but we have a pretty high level for income. Yeah, just fill out the intake, and we will reach out to you and let you know, and we go from there. Okay, so Val's there. She's looking at me. I want to thank you so much. I know I kind of wander around and stuff. I always find these things fascinating. I thank you for your questions because it also makes me think. I've been doing this 25 years, doesn't mean I know everything. It doesn't. So thank you so much.